The event of my disqualification is distressing and traumatized to me personally, and of course, a greater trauma inflicted on my party, the governorship candidates, and the good people of Bayelsa State who signified their choice of who should be their governor and deputy governor. It is this unsolicited assault on my personality and reputation by the judgment in question that has constrained me to chart this course of action. Let me start by saying that I condemn in strong terms all forms of forgery, impersonation, or criminality in any form by the political class, and I have never been associated with same. All the educational qualifications I presented to the Independent National Electoral Commission to aid my constitutional qualification were acquired by me personally from institutions here in Nigeria, which fortunately for us all are still in existence till date. The records are verifiable anytime, any day here in Nigeria.
Well, that's the next item on our agenda this morning. You are not unaware that the Supreme Court may witness more calls for a review of its judgments as the ruling All Progressives Congress files an application asking the court to reverse its decision disqualifying the party's candidate in the last governorship election in Bayelsa State.
Well, that's right. Now, the party's legal team, which is headed by Wole Olanikbekun and Lateef Fagbemi, want the apex courts to set aside what they call the wrong interpretation given to its judgment of February the 13th, 2020.
Now, the party is contending that the Supreme Court misinterpreted the November 12th, 2019 judgment of the Federal High Court Abuja, which it affirmed. Now, to discuss this conversation, to have this conversation with us, we have the Senior Advocate of Nigeria, Paul Ananaba, joining us. Thank you for being here this morning.
Thank you.
We have often heard from you and your colleagues that the Supreme Court is the apex court.
Yes.
The Supreme Court's decision is final.
Yeah.
With this call, is it still final?
Yes, it remains final. This is why in legal jurisprudence we say there's a Latin maxim, inter republicae finicit litium. That is, it is in the interest of the state that litigation should abound. That is where it is. In Nigeria, when we learn anything, we become extraordinary in it. What is now imagined is for everyone to question the decision of the Supreme Court, and it is very sad. Now, if the Supreme Court, for example, agrees with any of the parties that wants a review, and that party goes back and says, no, the reasoning is wrong, it goes back to Supreme Court again and say, review that your review. And the other one says, no, what has been decided, it should be further reviewed. And that's why the Constitution makes the Supreme Court, we should learn to lose or win.
But sorry, Kadi, the issue that many are raising, and some of your colleagues also, is that this decision of the Supreme Court is based on a pre-election matter, which shouldn't even have come this far at all in the first place.
No, that's a wrong position. Electoral matters are either pre-election or post-election. A pre-election matter has no limit. It will get up to the Supreme Court, and several have done so. But you could recall Organ, Ipazu, and all that. They were all pre-election matters.
But it's a pre-election matter.
Yes.
And now it's post-election.
No, it's not post-election. It still remains pre-election. It is whether...
So you don't think it should have been discussed before the election?
No, the Constitution is very clear. 14 days after publication of the qualification of the parties, if any person can go to court over that. Are you with me? Any person. Section 31 of the Electoral Act. Any person. So, since they came in within the window of the fourth alteration of 14 days, the Federal High Court is a court to go to. And I had to go to the Federal High Court, the Court of Appeal, and then the Supreme Court.
Right. Now, what the APC is asking for is they're saying that they want the Apex Court to set aside what they call wrong interpretation of the judgment. Now, two things here, interpretation of the judgment and the judgment itself. So, is this the judgment or an interpretation of the judgment? It's not clear.
Well, that's semantics. What they are saying is that the judgment should be reviewed. And I've come across so many interpretations about Judge Soputa's view in Adesoya, Adegogomotos and Adesoya, that the Supreme Court can make mistakes and review. It's rare to go back on the same case. I think what Judge Soputa was talking about is that that principle will naturally come up again. And the Supreme Court can look at it and say, oh, in the view of this and that, we have to depart from our earlier position. And we've seen that many times. So what you are now seeing is, in a space of few days, how many cases people are now filing application back to Supreme Court, even when they know that the Supreme Court is final. Some of them is just to question the integrity of the Supreme Court. Why will you bring down the institution of the Supreme Court? There is no decision of the Supreme Court that all parties will like.
So when you said earlier that this is sad, I recall you said that this whole narrative is sad. Is it that it is wrong, it is not right in the eyes of the law, or it is just sad? I mean, what does the law really say about this?
We've had elections and election petitions and decisions of the Supreme Court over time. How many times have you had that? This is a development that is frightening. For me as a practitioner, it's frightening.
But it seems the law allows it.
I don't know the provision of law that allows it.
Because we see your colleagues doing this over
Just
and
as
over
the law allows you, whichever application that is filed before any court, the court cannot sit on its own and say, oh, we'll not listen to it. They'll just listen to it. That is to the extent you can file the application. That is fair hearing. And even if you're going to say no, we'll hear it and say, my friend, no. But what we are talking about is the Supreme Court, as I speak to you, cases that were filed 10 years ago have not gotten data at the Supreme Court. And by the time anyone can just come to review as it's going on now. These reviews these cases are given priority. So cases 12, 13 years will not be heard in the Supreme Court. So and you look at the number of judges to the point that the National Assembly is complaining. Now, you bog the Supreme Court down because of coming to review, either to interpret or that. In a deserving case or cases that will be very sparingly seen, the Supreme Court can be called upon to review. But you are looking at how many cases already. It's now becoming a practice.
So you think
that is what I'm saying is sad, and it's not.
So the substance of this is the talk about the variation of names, and this has caused a lot of debate and what have you. What does the law say about that?
No, it's not about variation of names. We play politics with everything. The law is as stated in the Electoral Act. Now let's start from even the candidates. If you read section 182 and 187 of the Constitution, you come up with certain things. Clearly constitutional provisions. One, you cannot have a governorship candidate without a deputy or a running mate. And that governorship candidate cannot be validly nominated without that deputy. And in fact, Section 187.2 says that everything that appertains to the deputy also will affect the governor for election qualification and all that and all that. Now they filed their nomination documents in CO1 and all that before INEC. 14 days, the Constitution, fourth alteration of the Constitution now says within 14 days, if I complain, come up. PDP goes up to say, no, your deputy is not qualified. So you have not nominated a deputy. Now, having not nominated a deputy, you are not qualified yourself. It was before Justice Eko, and arguments are taken. The judge says, yes, your deputy is not validly nominated because that there's an allegation of falsehood. I mean, if the electoral act says if any content of that any of the either affidavit or document is false.
But it was an allegation, like you said.
Because this is not a criminal trial. This is not a criminal trial. It's an electoral proceeding. Because that the man has what has been presented did not disclose clearly that there are 5 different names.
But is there any law against changing your name?
There is no such law, but then you must change your name in accordance with the provisions of the law, which the Supreme Court, in its judgment, stated this is the provision. If you have to start and conclude. You cannot change your name on your degree certificate on your own. You take steps, you are informed the university, I have changed my name. Now there was a recent decision of the Court of Appeal, recent decision, where this issue where the court came to a decision that if you know of anything that will affect your candidature and you did not disclose it, we're not talking about what you have disclosed now alone. What did he disclose? You understand? The 5 variations of the name and all that. That's where the court went to. So if nobody is worrying whether you change your name, but did you complete the process? That's what is in the judgment. Number 2, did you tell INEC, this is my name now? I have had these names before. Now, if you did not do that, it means that you did not do full disclosure.
But
that's what the court came to.
But that's not to say he's not qualified, as it were.
Now, when you now have that it is enough to disqualify you, because you have not. Falsehood includes disclosure and non-disclosure.
It also doesn't mean that the political parties involved are not informed of all of these.
Well, you don't do conjecture. Okay. You don't do the conjecture. The duty is on you. If you have changed your name 10 times, the duty is on you to disclose, I have changed my name 10 times. And annex the document showing the changes to your from C001. That's the point. These matters are in court. I'm not discussing the case or argument on one side or the other. I'm just saying this is what the Supreme Court was saying in its judgment, that the process was not completed. Okay. That's my understanding of the Supreme Court judgment. And it is not a fresh judgment. It is a judgment that flows from the judgment of the Federal High Court.
Now, we also see the party's sacked deputy governor who spoke just before he came back, saying he's going back to court, saying that the court did not give him a chance to defend himself. In fact, that's one of the issues they are taking back to court.
Well, the Supreme Court will hear him and decide it one way or the other. But I think that the issue of whether he was qualified or not with respect to the name, is there any argument he wants to present that he did not present before the 3 courts? If he did not present it, why didn't he? If he presented them, the pronouncement has been made. Remember, once the Supreme Court makes a pronouncement, that is final. And we should come to terms with it. Okay. Whether it is painful or sweet.
Okay.
Is it even possible, pardon me, because like I said, he's saying that he didn't get the opportunity to defend his qualifications, saying that the Supreme Court did not give him that chance before deciding that it's forged. Is that even possible?
There was a federal high court where the issue of his name, where he was challenged. That is the point to present your case. Let me explain to you.
All right.
The law is not about that fair hearing is that hearing willy-nilly. You must be. It's to give you opportunity to be heard. Did he have opportunity to be heard? Those are things the Supreme Court will decide.
Okay. Now,
But what I don't accept is if a judgment did not favor any party, the party now makes it a media issue, trying to pull down the Supreme Court. The Supreme Court should be respected because that is the only place we can run to.
okay. Now, speak to this also. I don't even know how to put this, but let me just put it the way it's coming to me right now. That's the fact that each party has a team of lawyers who are supposed to advise their clients. In other words, what do you think? Should this case have gotten this far, if the judicial officers, the lawyers, the counsels to these parties have done their jobs correctly?
Thank you. I don't know whether you have advised a political party before or you've been a lawyer to a politician.
Tell us about it.
Then you will understand. You know, there are things that Harvard Law School will not teach you. And they cannot be exhausted in this studio now. But let me explain to you what happens. When the politicians are bent on going in a particular way, your legal advice will remain legal advice. It will not have any weight. Once the party has made up its mind where it's going, that's what the problem is. But in places where politics is played according to rules, such advice is important. And if we have such case and this type of result comes, the advisors will be called to question. Did you do your job? But it does appear to me that we've not gotten there. And two, when some of these appointments are made, perhaps the best hands who could give the appropriate, the best team may not be put in place. So it's not all about being a lawyer. There may be specializations, understanding and experience. So your team also determines what result you get.
Let me put you on the spot here and ask, if you were to advise, what kind of advice would you be giving them?
Why are we giving them? Well, why will I be giving them advice? For them to get the advice now. Why wouldn't they? Now, but the point is, strictly speaking, my brother, when you deal with any professional team group, it's always good to have a second opinion. You understand? Many times you get it in the court when it is very painful. And when you get good advice, use it. Now, the point I'm making is, didn't the party screen their candidates? Why should everything be heaped on the judiciary? Did the candidates disclose any change of name or variations at their screening? Did the party ignore it? So when you don't do your homework, you look for the judiciary. And that's why I believe that the judiciary should be let out of all these problems. Parties should do their homework.
It's a little scary now because, I mean, if legal counsel comes and the legal counsel comes with, look, these are the implications, or this is the implication, this is the likely result of not following this counsel that I'm giving you, and they still go ahead?
It happens in companies, not even political parties, in churches, in mosques, in everything, because we ignore. Why do you have continuous failure or building collapse, bridge collapse in Nigeria? Don't you see that?
So what option does a legal practitioner have then?
Resign honorably.
Or just go ahead with it still?
Resign honorably. That's what our profession teaches.
If you give advice and they do not follow it, you resign.
No, if it gets to the point that your advice is being ignored, you are no longer relevant there. It's a profession of integrity.
Okay, so what counsel would you, okay, now, this is probably not cheap, but what counsel would you be
No,
giving to both parties now?
I'm not giving parties any counsel. I'm speaking to Nigerians.
Okay.
I am saying that our Supreme Court is precious. We should save our Supreme Court from politics. Insulate our courts from politics.
Okay.
Parties should do their homework, frankly, because I can tell you, if you advise that Mr. A is not qualified as a lawyer based on the constitutional requirements and all that, and that this is going to be, will Mr. A not see you as being sponsored by his opponents to ensure he is not a candidate?
Okay. Well,
Now, we should begin to do things rightly. Okay. Again, I go back to orientation in this country.
You know, Mr. Anaba, I think we'll find us to resign for now because of our time. But we'd like to thank you so much for at least shedding some light on this issue. We've been speaking with Mr. Paul Anaba. He's a senior advocate of Nigeria. Thank you so much.
Thank you.
All right, back in a moment. Please stay with us. Just before we go, let's take a look at some of the responses that you have sent in. This one, first one, is from Jogboski, and he says, there are multi-levels of responsibility demanded from all, but at all times, the right to freedom of expression and that which enables the media press to do its work freely must be protected. It's in the interest of all, especially for any accountable government.
Well, Petoski 13 tweets about social media regulation, saying the bill to regulate social media is just a serious waste of time and resources. Our leaders should understand that technology cannot be held down. This next one is quite tricky. It says, with a free VPN, one can be in Nigeria and operate as if he was in Cambodia. How will they handle that? Are you giving ideas there, Petoski? Well, there you go.
And this one is from Deolu Oyebode, who says, talking about citizen journalists, disinformation by citizen journalists has reduced press freedom in Nigeria. As a matter of fact, most of these bloggers aren't trained by any media institute, either NIJ or IIJ. That you're skilled in healing doesn't mean you're a qualified doctor.
And Zimo says here, the attempt to sanitize the socials is just a diversion from the real issues. With the myriad of problems bedeviling us, why is censoring posts on the socials an issue? And just how do you gag a Nigerian in diaspora from posting what he likes on the socials? That's the question there.
I kind of like the new term, socials.
Socials, right?
You can join us, by the way, on all our socials across Twitter, Instagram, Facebook, and YouTube.
Do we still have time for just one more thing?
Okay, we don't.
Oh, we don't. All right. All right, it's time for us to go then. Thank you so much for watching, for sticking with us this week. I'm Ayo Makinde. Have a wonderful day.
And I'm Kayode Okikiolu.
And I'm Maokpe Ogun Yusuf. See you later tonight.